In the criminal justice system of Beecham County, Alabama, murder is considered especially heinous. One dedicated attorney from New York City is determined to investigate these crimes. He is known as My Cousin Vinny.
A little informal, aren't we?
I was just resting.
And not wearing a coat or a tie.
Sorry.
Well, approving an attorney from out of state is a pretty informal matter. I just have a few questions.
Fire away, Judge.
Well, where did you go to law school?
Brooklyn Academy of Law.
Is that an accredited law school?
Yeah.
Well, how long you been practicing?
Oh, about almost 16 years.
Any murder cases?
Lots of them. Quite a few, actually. Yeah.
Well, then what was the outcome?
Oh, you win some, you lose some.
This is not the form to be cavalier.
No, of course not. Now, let me see. Well, most recently, I had an axe murder, which I won on the grounds of temporary insanity. You want to hear the facts of the case?
No. What else?
Let me see. What else? You ever heard of Son of Sam?
The fella who received orders to kill from a dog?
That's the one.
You defended him.
Well, no, not exactly. I defended the guy they arrested first, and he was found innocent and set free, and so then they caught the other guy.
Well, we don't have any serial killers here in Beecham County, but we do have is every bit of a sophisticated system of justice as they do in the rest of the country.
Oh, I'm sure.
You, being from New York and all, might have the impression that law is practiced with a certain degree of informality down here, isn't it?
Right.
I tell you this because I want you to know that when it comes to procedure, I am not a patient man. I advise you, sir, when you come into my courtroom, you are to know the letter of the law. I react harshly when you don't.
You shouldn't.
Don't think being from New York, you're going to get special treatment.
I shouldn't.
You won't. You'll be given no leeway whatsoever. I expect you to know this information when you come into my courtroom.
Right.
Are you willing to accept those terms?
Yeah, right. No problem.
Is your attorney here?
I'm the attorney.
Oh. Jim Trotter III, District Attorney, Beecham County.
Vincent LaGuardia Gambini, the first. Brooklyn.
Oh, it's nice to meet you.
All rise for His Honor, Judge Chamberlain Holler. The Court of Beecham County is now in session. Be seated. First case, the people of the state of Alabama versus William Robert Gambini and Stanley Marcus Rothenstein.
Counselor, your clients are charged with first-degree murder. How did they plead?
My client ain't done nothing wrong. You know what I mean?
Don't talk to me sitting in that chair.
But they told me to sit here.
When you are addressing this court, you will rise and speak to me in a clear, intelligible voice.
Sorry. My clients, they ain't done nothing wrong.
What,
See,
what are you wearing?
Huh?
What are you wearing?
I'm wearing clothes. I don't get the question.
When you come into my court looking like you do, you not only insult me, but you insult the integrity of this court.
I apologize, sir, but
next time you come into my courtroom, you look lawyerly. And I mean you comb your hair and wear a suit and tie. And that suit better be made out of some kind of cloth. You understand me?
Yeah, fine. Fine, Judge.
Good. How do your clients plead?
My clients, they was caught completely by surprise. They thought that they was getting arrested for shoplifting a can of tuna or something.
What are you telling me? That they plead not guilty?
Nah, I'm trying to explain to you. See,
I don't want to hear explanations. The state of Alabama has its procedure, and that procedure at this point in time is to have an arraignment. Are we clear on this?
Yes, Your Honor. But there seems to be a great deal of confusion here.
Mr. Gambini.
See, my clients, they were simply just going into the store and then they...
Mr. Gambini, all I ask from you is a very simple answer to a very simple question. There are only two ways to answer it: guilty or not guilty.
Your Honor, my clients didn't do nothing.
Once again, the communication process is broken down. It appears to me that you want to skip the arraignment process, go directly to trial, skip that, and get a dismissal. Well, I am not about to revamp the entire judicial process just because you find yourself in a unique position of defending clients who say they didn't do it. Now, the next words out of your mouth are either going to be guilty or not guilty. I don't want to hear commentary, argument, or opinion. If I hear anything other than guilty or not guilty, you'll be in contempt. I don't even want to hear you clear your throat. I hope I've been clear. Now, how do your clients plead?
I think I get the point.
No, I don't think you do. You're now in contempt of court. Would you like to go for 2 counts of contempt?
Not guilty.
Thank you. Bail will be set at $200,000. Preliminary hearing will be set for 9:30 a.m. tomorrow morning. Bailiff, please take Mr. Gambini into custody. Bail will be set at $200.
All rise.
Then I heard 2 loud bangs like firecrackers. I looked up and I saw 2 young men run out of the sack of suds and jump into a green car with a white convertible top and drive off like the Dickens.
Oh, Mrs. Riley, are those 2 young men present in the courtroom today?
Well, yes, sir, they are.
Could you point them out for me, please, ma'am?
Well, they're sitting right there.
Uh-huh. Now, Mrs. Riley, is this the car?
Well, now, yes, sir, it is.
Thank you, ma'am. Let the record show Mrs. Constant Riley identified the defendant's car.
I was making my breakfast. I saw them 2 boys go into the store. Then later, I heard a gunshot. Looked out the window. They were running out, got into the car and drove off.
Mm-hmm. Is this the car?
Yes, it is.
You saw those 2 boys run out of the sack of suds, jump in this car and take off?
Mm-hmm. Yeah, they peeled away. Car was all over the road.
Thank you, ma'am.
Mr. Gambini,
Yeah.
you have anything to add?
Thing? What thing?
It's not for me to say.
No, sir.
You can stand down, ma'am. Do you have any other witnesses?
No, Your Honor.
The court finds sufficient evidence to exist for this matter to go to trial. I'm setting this matter for trial this Monday, February 2nd at 10 a.m. Mr. Gambini, now didn't I tell you next time you appear in my court that you dress appropriately?
You were serious about that?
Mr. Gambini, are you mocking me with that outfit?
Mocking you? No. I'm not mocking you, Judge.
Then explain that outfit.
I bought a suit. Now it's covered in mud. This town don't have a 1-hour cleaner, so I had to buy a new suit. Except that the only store that you could buy a new suit has got the flu. You hear that? The whole store's got the flu. So I had to get this ridiculous thing from a secondhand store. So it's either wear the leather jacket, which I know you hate, or this.
So I wore this ridiculous suit for you.
Are you on drugs?
Drugs? No, I don't take drugs.
I don't like your attitude.
What else is new?
I'm holding you in contempt of court.
There's a frickin' surprise.
What did you say?
What?
What did you just say?
What'd I say? What?
Your Honor, counsel, members of the jury, the evidence in this case is going to show that at 9:30 in the morning of January 4th, both defendants, Stanley Rothenstein and William Gambini, were seen getting out of their metallic green 1964 Buick Skylark convertible with a white top. The evidence is going to show that they were seen entering the Sack-O-Suds convenience store in Wazoo City. The evidence is going to show that minutes after they entered the Sack-O-Suds, a gunshot was heard by 3 eyewitnesses. You're going to then hear the testimony of the 3 eyewitnesses who saw the defendants running out of the Sack-O-Suds a moment after the shots were heard, getting into their faded metallic green 1964 Buick Skylark and driving off in great haste. Finally, the state is going to prove that the defendants, Gambini and Rothenstein, admitted, then recanted, their testimony to the sheriff of Beecham County. Now let's get down to the link lock. Your verdict is going to depend on what you think of the sworn testimony, not what I think. What I think don't count. You're the jury. It's your job to decide who's telling the truth. Truth. That's what verdict means. It's a word that comes down from old England and our little old ancestors. Now we're going to be asking you to return a verdict of murder in the first degree for William Gambini and a verdict of accessory to murder in the first degree for Stanley Rothenstein for helping Gambini commit this heinous crime.
Counselor, do you wish to make an opening statement? Counselor,
What?
do you wish to make an opening statement?
Oh, everything that guy just said is bull. Thank you.
Objection, Your Honor. Counsel's entire opening statement is argument.
Objection sustained. The entire opening statement, with the exception of thank you, will be stricken from the record. The jury will please disregard the counsel's entire opening statement. And you, Mr. Gambini, you will not use that kind of language in my court. You understand me?
Yeah.
Well, that was just great.
Oh, yeah? Well, Mr. Public Defender, you think you can do better? Be my guest.
Don't worry. I'll have the jury in the palm of my hand.
Counselor, your statement, sir?
Well, now, ladies and gentlemen of the the jury, on January 4th of this year, my client did indeed visit the Sack-O-Suds convenience store, but he didn't kill anyone. We intend to prove that the prosecutor's case is circumstantial and coincidental. Thank you.
That's it?
I get nervous sometimes. I'm getting better.
I heard a gunshot, so I looked out the window. I seen them two boys run out, get into their car, and drive off like maniacs. Tires screeching, smoking, going up on the curb.
Is this the car?
Yes, sir.
Thank you, ma'am. No further questions, Your Honor.
Your witness.
All right, Miss. Uh, 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 um, um, uh, Tipton. Um, now, when you viewed my clients, how far away were you? About 50 feet. Oh, now, do you think that's close enough to make an accurate identification?
Yes.
Miss Tipton, I see you wear eyeglasses.
Sometimes.
Thank you. And now, Miss Tipton, were you wearing them that day?
No.
You see, you were 50 feet away. You made a positive eyewitness identification, and yet you were not wearing your necessary prescription eyeglasses.
They're reading glasses.
Well, Mrs. Could you tell the court what color eyes the defendants have?
Brown, hazel green.
No more questions.
Mr. Gambini, your witness.
Oh, she's a tough one.
Mrs. Tipton, when you viewed the defendants walking from the car into the sack of suds, what angle was your point of view?
They was kind of walking toward me when they entered the store.
And when they left, what angle was your point of view?
They were kind of walking away from me.
So, would you say that you got a better shot of them going in and not so much coming out?
You could say that.
I did say that, but would you say that?
Yeah.
So is it possible that the two youths,
The two what? What was that word?
huh? What word?
Two what?
What?
Did you say Utes?
Yeah, the two youths.
What is a Ute?
Oh, excuse me, Your Honor. The two youths. Is it possible that the two defendants entered the store, picked 22 specific items off the shelves, had the clerk take their money, make change, then leave, then two different men drive up in a similar... No, you don't have to shake your head. I'm not done yet. Listen. Wait till you hear the whole thing so that you can understand this now. Listen. Is it possible that two different men drive up in a similar looking car, go in, shoot the clerk, rob him, and then leave?
No, that didn't have enough time.
Well, how much time was they in the store?
5 minutes.
5 minutes? Are you sure? Did you look at your watch?
No.
Oh, yeah. I'm sorry. You testified earlier that the boys went into the store and you had just begun to make breakfast. You were just ready to eat and you heard a gunshot. That's right, right? I'm sorry. So obviously it takes you 5 minutes to make breakfast.
That's right.
So you knew that, of course. Do you remember what you had?
Eggs and grits.
Eggs and grits. I like grits too. How do you cook your grits? You like them regular, creamy, or al dente?
Just regular, I guess.
Regular. Are they instant grits?
No self-respecting Southerner uses instant grits. I take pride in my grits.
So, Mrs. Tipton, how could it take you 5 minutes to cook your grits when it takes the entire grit-eating world 20 minutes?
I don't know. I'm a fast cook, I guess.
I'm sorry. What was that? I couldn't hear you for a minute. Did you say that you're just a fast cook? That's it? Are we to believe that boiling water soaks into a grit faster in your kitchen than in any place on the face of the earth?
I don't know.
Well, perhaps the laws of physics cease to exist on your stove. Were these magic grits? I mean, did you buy these grits from the same guy who sold Jack his magic beanstalk beans?
Objection, Your Honor.
Objection
Are you
sustained.
sure about them 5 minutes?
Ignore the question.
I don't know.
Are you sure about them 5 minutes?
I don't know.
I think you made your point.
Are you sure about them 5 minutes?
I may have been mistaken.
I got no more use for this witness. Now, Mr. Crane, what are these pictures of?
That's my house and stuff.
House and stuff. Good, yeah. And what is the brown stuff right here on the windows? What's that?
Dirt.
Dirt. And what is this rusty, dusty, dirty thing over your window?
That's a screen.
Oh, screen.
That's a screen. That's a screen.
Green. And what are these right here? What are these big things right in the middle of your view from the window of the kitchen to the sack of suds? What do you call these big things?
Trees.
Trees. Oh, that's nice, right? Now don't be afraid. Just go ahead and shout out the answer if you know it, okay? Now, oh, here's a lovely one. What are these thousands of little things on the trees?
Leaves.
Leaves. That's right. And these bushy things between the trees. What are them?
Them's bushes.
Bushes. Right. So, Mr. Crane, could you positively identify the defendants for a moment of 2 seconds looking through this dirty window, this crud-covered screen, these trees with all these nice little pretty little leaves on them, and I don't know how many bushes. What is that?
Looks like 5.
Now don't forget this one and that little one right there.
7 bushes. 7.
7 bushes. So what do you think? Is it possible that you just saw two guys in a green convertible and not necessarily these two particular guys?
Well, I suppose.
I'm finished with this guy. Now, Mrs. Riley, when you saw the defendants, were you wearing your glasses?
Yes, I was.
Over here, dear. Over here. Over here. Good. Right here.
Oh, there you are.
Yeah. Would you mind putting on your glasses for me, sweetheart?
Oh,
Please.
sure.
Oh, whoa. How long you been wearing glasses?
Well, since I was 6.
Have they always been that thick?
Oh, no. They got thicker over the years.
So, as your eyes got more and more out of whack and you gotten older, how many different levels of thickness have you gone through?
Oh, I don't know. Over 60 years? Maybe 10 times.
Maybe you need a thicker set?
No. I think they're okay.
Well, maybe we should just make sure, okay? Let's check this out.
Okay.
Now, how far were the defendants from you when you saw them entering the sack of suds?
Well, about 100 feet.
100 feet. Okay. Now, Mrs. Riley, I am now 50 feet away. That's half the distance. How many fingers am I holding up?
Let the record show that counsel is holding up 2 fingers.
Your Honor, please, huh?
Oh, sorry.
Okay. Now, Mrs. Riley, and only Mrs. Riley, how many fingers am I holding up now?
4.
What do you think now, dear?
Oops. I'm thinking of getting thicker glasses.
Thank you.
Mr. Wilbur, what is your profession?
I'm a special automotive instructor of forensic studies for the Federal Bureau of Investigation.
How long you been in that position?
18 years.
Your Honor, may we approach the bench, please?
If you wish.
I object to this witness being called at this time. We've been given no prior notice he testified, no discovery of any tests that he's conducted or reports that he's prepared. And as the court is aware, the defense is entitled to advance notice of any witness who will testify, particularly those who will give scientific evidence, so that we could properly prepare for cross-examination, and well as to give the defense an opportunity to have the witnesses' reports reviewed by a defense expert who might then be in a position to contradict the veracity of his conclusions.
Mr. Gambini,
Yes, sir?
that is a lucid, intelligent, well thought out objection.
Well, thank you, Your Honor.
Overruled.
Now, Mr. Wilbur, these are photos of tires belonging to the defendant's car, and these are photos of the tire marks left by the assailant's car as it fled the convenience store. Now, are you familiar with these?
Yes, I am.
Could you elaborate, please, sir?
Well, we compared the tire marks outside the convenience store with the rear tires of the defendant's car. They're the same model, same size tire. Michelin model XGV size 75R 14-inch wheel.
They're the same size and model tire. Anything else, sir?
Yes, indeed. The car leaving the convenience store spun its rear tires dramatically and left a residue of rubber on the asphalt. Now, I took a sample of that rubber and analyzed it. I also took a sample of the rubber from the rear tires of the defendant's Buick and analyzed that too.
What kind of equipment did you use to find this out?
I used a Hewlett-Packard 5710-A dual-column gas chromatograph with flame analyzation detectors.
Is that thing turbocharged?
Only on the floor models.
Oh, now, Mr. Wilbur, what was the result of your analysis?
The chemical composition between the two samples was found to be identical.
Identical. No further questions, Your Honor.
Your Honor.
Thank you, Mr. Wilbur. The court will take a 60-minute recess for lunch.
Your Honor, I respectfully request a full day's continuance so that I can go over this stuff.
Request denied.
Thanks a lot. Is it possible that two separate cars could be driving on Michelin model XGV 75R14s?
Of course.
Let me ask you this. What's the best-selling single model tire being sold in the United States today?
The Michelin XGV.
And what's the most popular size?
75R14.
The same size as on the defendant's car.
But two faded green 1964 Buick Skylark convertibles?
Excuse me. What I'm asking you is if the most popular size of the most popular tire is on the defendant's car.
Well, yeah.
Yes. Thank you. No further questions.
The witness can step down. Counsel?
Your Honor, the prosecution rests.
Mr. Gambini, your first witness.
Your Honor, the defense calls as its first witness Miss Mona Lisa Vito.
I object, Your Honor. This person is not on the witness list.
This witness is an expert in the field of automobiles and is being called to rebut the testimony of George Wilbur.
Very well. Hello, miss. You just go right on ahead and have a seat right there. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Miss Vito, you're supposed to be some kind of expert in automobiles. Is that correct? Is that correct?
Will you please answer the counselor's question?
No, I hate him.
Your Honor, may I have permission to treat Miss Vito as a hostile witness?
You think I'm hostile now? Wait till you see me tonight.
Do you two know each other?
Yeah, she's my fiancée.
Well, I would certainly explain the hostility.
Your Honor, I object to this witness. Improper foundation. I'm not aware of this person's qualifications. I'd like to voir dire this witness as to the extent of her expertise.
Granted. Mr. Trotter, you may proceed.
Miss Vito, what's your current profession?
I'm an out-of-work hairdresser.
An out-of-work hairdresser. Now, in what way does that qualify you to be an expert in automobiles?
It doesn't.
Well, in what way are you qualified?
Well, my father's a mechanic, his father's a mechanic, my mother's father was a mechanic, my three brothers a mechanic, and my 4 uncles on my father's side are mechanics.
Well, Miss Vito, your family's obviously qualified, but have you ever worked as a mechanic?
Yeah, in my father's garage, yeah.
As a mechanic? What'd you do in your father's garage?
Tune-ups, oil changes, brake realigning, engine rebuild some trannies, rear ends.
Okay. But does being an ex-mechanic necessarily qualify you as being an expert on tire marks?
No, Thank you. Goodbye.
Sit down there and stay until you're told to leave.
Your Honor, Miss Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voyeur-dire the witness as to the extent of her expertise in this area, I'm sure he's going to be more than satisfied.
Okay. All right. All right. Now, Miss Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic engine and a 4-barrel carburetor?
That's a bullshit question.
Does that mean you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Miss Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Because Chevy didn't make a 327 in 55. The 327 didn't come out until 62, and it wasn't offered in the Bel Air with 4-barrel carb to 64. However, in 1964, the correct timing ignition would be 4 degrees before top dead center.
Well, she's acceptable, Your Honor.
Your Honor, this is a picture taken by my fiancée outside of the sack of suds. Do we agree on that?
Yeah.
Thank you. I'd like to submit this picture of the tire tracks as evidence.
Mr. Trotter?
No objection, Your Honor.
Now, Ms. Vito, did you take this picture?
You know I did.
And what is this a picture of?
You know what it's of.
Miss Vito, it has been argued by me, the defense, and these two sets of guys. Let me start that line again. Miss Vito, it has been argued by me, the defense, that these two sets of guys met up at the sack of suds at the same time, driving identical metallic mint green 1964 Buick Skylark convertibles. Now, can you tell us by what you see in this picture if the defense's case holds water? Ms. Vito, please answer the question. Does the defense's case hold water?
No, the defense is wrong.
Are you sure?
I'm positive.
And how can you be so sure?
Because there is no way these tire marks could be made by a 64 Buick Skylark. These tire marks were made by a 1963 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact.
Now, I find it hard to believe that this kind of information could be ascertained simply by looking at a picture.
Would you like me to explain?
I'd love to hear this.
So would I.
The car that made these two equal length tire marks had positive traction. Can't make these marks without positive traction, which was not available in the 64 Buick Skylark.
And why not? What is positive traction?
It's a limited slip differential which distributes power equally to both the right and left tires. The 64 Skylark had a regular differential, which anyone who's ever been stuck in the mud in Alabama knows you step on the gas, one tire spins, the other tire does nothing.
Is that it?
No, there's more. You see how the left tire mark goes up on the curb and the right tire mark stays flat and even? The 64 Skylark had a solid rear axle, which means the left tire goes up on the curb, the right tire mark tilts out and rides along its edge. But that didn't happen here. The tire mark stayed flat and even. This car had an independent rear suspension. Now, in the 60s, there were only two cars in America that had positive traction and independent rear suspension and enough power to make these marks. One was the Corvette, which could never be confused with the 64 Buick Skylark. And the other had the same body length, height, width, weight, wheelbase, and wheel track as the 64 Buick Skylark, and that was the 1963 Pontiac Tempest.
And because both cars were made by GM, were both cars available in metallic mint green paint?
They were.
Thank you. Thank you, Miss Vito. No more questions. Thank you. Thank you very much. You've been a lovely, lovely witness.
Mr. Trotter, would you like to question Ms. Vito? Mr. Trotter. Mr. Trotter.
No, Your Honor. No further questions.
In that case, Your Honor, I'd like to recall George Wilbur.
Ms. Vito, you can stand down. You realize you're still under oath?
Yes, sir.
Now, Mr. Wilbur, how'd you like Miss Vito's testimony?
Very impressive.
And she's cute too, huh?
Yes, very.
Mr. Gambini.
Sorry, Your Honor. Mr. Wilbur, in your expertise opinion, would you say that everything Miss Vito said on the stand was 100% accurate?
I'd have to say that.
And is there any way in the world the Buick that the defendants were driving made those tire tracks? Come on, you can say it, it's okay. Everybody knows.
Actually, no.
No. Thank you. No more questions. The defense rests.
Mr. Trotter.
Your Honor, in light of Mr. Wilbur and Miss Vito's testimony, the station would like to dismiss all charges.
Yes!
All right. Order in the court. Case dismissed.